Adam, again, to go back to the morning, which was a long time ago for all of us, and Todd Blanche's defense argument. Because we're going to cover a lot of prosecution. One of the things I say about the prosecution is that the evidence that the prosecution has is very familiar to our audience, because that's been available to us for a very long time. We've been presenting most of it here for a very long time. What we always were sitting around waiting for is, what's the defense? What is the defense of this? And so now that we heard today's most cogent presentation of the Trump defense in this case, Todd Blanche kept coming back to reasonable doubt, reasonable doubt, reasonable doubt. He wasn't going for an innocent. He wasn't going for that. He understood, look, Donald Trump cannot be defended as an innocent person. Donald Trump did stuff within this story that you're not going to like. But did Todd Blanche wedge in enough reasonable doubt for a jury to cling to?
I think the answer to that question helps explain why Josh Steinglass went so long. I think the strongest part of Blanche's presentation was in the morning when he stuck to the law. There was this one part where he was talking about the intent to defraud, and there's one line: there's no other way to characterize an invoice from a lawyer to President Trump than to call it a legal expense. The government has criminalized that, has said that was a crime. What the payroll administrator did, that's absurd. It's not a crime. And he said later, he talked about the mechanics of how these ledger entries were entered. And he pointed out it was a drop-down menu. And presumably from the drop-down menu, there isn't hush money to porn star. So when he resigned himself to the law, that was the strongest part of his defense summation. And I think where things started to go off, and I think where the Steinglass was very effective, is where Blanche started coming along with his rehearsed one-liners, calling Cohen the MVP of lies, the gloat, greatest liar of all time, the living embodiment of reasonable doubt. But he would do that in this kind of scattershot way. And I'm a little biased toward this moment here of what I thought was effective, because I predicted this moment on this show last week, where I said that it seems the defense is pushing this internal inconsistency, this logical inconsistency that's going to be called out by the prosecution, and Steinglass did.
Yes.
And the moment was when tarring Cohen as a thief, and that the defense wanted to have it both ways, in the word of the prosecution. And here's what Steinglass said: but in any event, none of this matters, because it's not a defense to the false business records charge that one of the co-conspirators is also guilty of stealing from another. And I will tell you something else that was kind of funny. And Steinglass actually laughed at that moment.
He presented this very well.
Yes.
Yeah.
And said, I don't know if someone caught this during the summation, but Mr. Blanche said, well, he stole $60,000, right? Because it was grossed up. But so that means that the defense is trying to have it both ways. They can call him a thief or claim this wasn't really a reimbursement, but not both.
Right. It's that internal conflict in the defense theories, Andrew, that I've been watching for, which is it's not a reimbursement. That's his paycheck. He earned his paycheck by doing legal work. And as Lisa points out, the DA said today, Michael Cohen spent less time doing legal work for that money than he spent in cross-examination in this courtroom. But so it's not a reimbursement, it's a paycheck. That's one defense argument. And then over here is the other defense argument that in this reimbursement formula, Michael Cohen lied about how much he should be reimbursed. And so he was reimbursed too much. We get to call him a thief because it's reimbursement. But wait a minute, you just called it a paycheck. And now you're saying he's a thief because it's reimbursement.
So in Todd's defense, I do not think it was a good summation, just to be clear.
Was there a way of him see, because I just sat there waiting for him to solve that problem in the case. Was there a way for him to solve it?
So first, it is not uncommon for defense lawyers to have very inconsistent arguments and facts, and because you're only trying to appeal just something to one juror, and you don't know what that one thing will be. So that you are presenting a whole range of things. And unlike sort of an appeal brief where you pick your best, suit and go with that, you really do try to present as much as you can and hope something sticks without saying something ridiculous.
Yeah.
He did. I mean, there were a few things where he shouldn't have gone there, where I'm pretty sure it's his client who insisted on it. But the reason I thought there was a real problem is, and the gift of Todd Blanche to this case and to Josh Steinglass was a little bit like the gift of Costello to Josh Steinglass, which is there is what Todd Blanche addressed and the huge problems with what he did not address. As you've pointed out, nothing in any way cogent about Exhibits 35 and 36, the handwritten notes by Weisselberg.
$130,000.
I mean,
never explained.
Never. I mean,
handwritten by Alan Weisselberg.
Those, everyone knew. We've been sitting here. We've talked about them over and over again. You have to have a theory. If you do not have a theory, your client better be pleading guilty. I mean, you have to have some theory. There was no discussion of Hope Hicks about any of the damaging testimony. Just to use her for some embroidery, but not to deal with the substance. A second problem. David Pecker, again, not dealing with the damaging information. Nothing was said about that. To then say about the Access Hollywood tape, the only thing you're going to say about it is it wasn't a big deal. I mean, again, you have to come up with a better argument or just not address it. So Josh Steinglass was just given all of these gifts because all of that proved nothing was said. And so that is, I mean, I kept on thinking Susan Neckles, who I keep on sort of praising, had to be sitting there dying because
she was physically as far away as she could be. She wasn't just at the end of the regular counsel table. She moved over to where the junior lawyers are to get even farther away today.
And she is the most experienced defense lawyer in that room, other than maybe Susan Hoffinger, who is now in the prosecution side. And you just can't give that closing argument as a defense lawyer. You have to come up with something. And, I'm not sure what I would say about Exhibit 35 and 36, but you have to bring it up. And look, you have to at least say Donald Trump is not on this. You do not know what they said to him or did not say to him. You don't know if Michael Cohen said, don't worry, I've already talked to Donald Trump about it, so you, Alan Weisselberg, don't have to. You have to say something about it to help explain it because you know that they're going to jump all over it. So to me, it's so hard to give them high marks because of what wasn't addressed.